Assistant Public Washington. Washington. Mr. Washington, is here. Please state your name for the record.
Washington. Washington.
Thank you, Judge. Obviously, I did not have this last time, but I am told that I'm asking for an adjournment of the PCC, and I am to address bond if the court will allow.
Please state your name for the record, sir.
Washington.
Thank you, sir.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment. And we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out. And we are also willing to address that one, whoever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 12/27 and 12/30 for cocaine. He did already send out the 12/27 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on, after court today, appearing in Community Corrections to have his most recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that be addressed at that time.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite frankly a possibility. He's staying on top of this, continued to test even after he did get that positive result, went to Community Corrections and paid the $30 to have that sent out.
You're going to have a test today?
Yes, he's appearing. He is going to go to Community Corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. If I send you over today and I get those results immediately, is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is not the only. This is probably the least case that I'm worried about. I'm on GPS tether. I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use at all. I'm not trying to pit everything out on the line. If we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street. Courtroom.
So, did you read over that progress report?
Me?
Yeah, because I'm getting a lot of people that are amoebas.
Yes, I did read over the progress.
They're absorbing cocaine. And I'm not sure how that happens. Young lady appears at Community Corrections, said, I smoked it around him. That must be how he's testing positive. You believe that? You believe, hold on, no. You believe that?
Yes, Your Honor.
Really?
That's the truth.
Counsel Bro, you might want to just be quiet, because the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Council approach. Anything else you want to say?
No,
I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests.
I understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address it at that time. If in fact the lab confirms that it was a positive result, I would ask for that, Your Honor, and I have nothing further to add. But except that Mr. Washington, I do truly believe will be in attendance to its next future court date.
I'm not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days, at least, in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
He's asked that we address bond again today. I have made a number of contacts. I've reached out to his community corrections agent. She indicated to me that in order for him to get into CCOP while in custody, the court would need to send over an order to their attention so that they could at least start the process. However, he wouldn't be able to do the assessment until he's out of custody. So I guess our first request today would be that the court consider an order allowing him to enter the CCOP program so that he could be assessed. I also reached out to Matt Statman to see if he could come to the jail and do an assessment. I know that the court would like to see some type of plan in place to address his sobriety. He didn't want to address the court again today. He indicated that he wanted to take responsibility and be open and honest to the court and explain to the court exactly.
So what changed? Why does he now want to be open and honest?
I think primarily, Your Honor, he indicates that he was extremely shameful of what had happened. I think he could better say it in his own words. His family is here. He knows that he's let them down significantly over the past few years. I think this started back in 2023, right?
Yes, ma'am.
Yeah. So he knows that he's let them down, and he just has not been very open with himself about the extent of his addiction. He and I had a great conversation. He has a lot of insight, and he told me himself that he is not great with words, but he's going to do his absolute best to try and express himself to his honor so that he could see and understand where he is in regards to.
His mom and dad here?
They are. His mom is that your dad?
Mom is
Yes, ma'am.
That's both of them.
No. This is my mom.
His mother is here, Your Honor.
What do you want to tell me?
First of all, I want to apologize for being dishonest with you. Like I say, whatever we can do to move forward and help me with the problem that I have, I just want to do the right thing, John. I'm not even gonna lie to you. Like I said, I'm not the best with words. So
I'm understanding everything you're saying.
I know. I just asked for another chance. Honestly, I do.
Well, not funny, but why were you lying to me? I mean,
I was just in disbelief.
did I look like that stupid?
No.
Huh?
No, I was lying to myself, honestly.
Point. But you had lied to your mother about that, right?
Right.
Right?
Yes, sir.
Because see, most people don't think I remember anything, but Mama was sitting on that side. All of a sudden, you may not have seen this, but all of a sudden, her baby was about to be in trouble, and Mom came all the way from that side over here because Mom was going to jump up and say anything she could to try to defend her child. Mom, am I right? And then the biggest disappointment was on her face because she couldn't defend you. So more than what you did to me, more than what you did to yourself, you did that to your mom. And I'm going to tell you, the way I am, that sometimes is a harder thing for me to forgive when you do that to your mom. Because I when I saw her coming over, I said, "Oh, what's she gonna do?" But because she was gonna battle for you, and that's who you really let down. You got me?
Yes, sir.
All right. So, Ms. Acker, what kind of plan?
So, Your Honor,
I mean, I understand CC. I get that part of it, but what kind of plan is in place for him so that I don't let him out of here, and then next thing I know, I'm having to put him back in because he can't.
and Your Honor, I think that I spoke with Mom today, and I know he was on tether initially, and I think Mom, again, not realizing the extent of the issue, understood that he could not go, but people came to the house. And that's where his next level of exposure happened. And I told him, I said, the tether can keep you from going places and have them monitor you, but it obviously didn't stop you from testing positive. And he explained to me that it was due to influences that he had allowed back into his circle and his bubble. So what Mom has assured me of is that now that she knows that his access is not just based on him going out, she, with it being her house, is also going to limit or prevent anyone from coming in to see him, especially while he's in this very vulnerable state and until we can get him secured into some type of treatment. That was the commitment that Mom made to me today. I will say something too, Your Honor. When I had spoken with him, this is part of what I was expecting him to say to the court. I asked him, I said, so why did you lie? And he said, because my mom was there and I didn't want to tell her the truth. I wasn't here at that last hearing, so it is quite funny that the court is able to see exactly what the root of that particular situation was.
I could see it on Mom's face. I just didn't know who was going to come at. I didn't know who was going to be at me or what it was going to be at, but I could also see the hurt on her face. And young man, you got to do better.
Promise to. I promise I won't drop dirty again.
All right, here's what I'm going to do. At this juncture, secondarily, I'm going to, well, is there anything from the people?
We'll leave it in your discretion, Your Honor.
All right, here's what I'm going to do at this point. Secondarily, I'm going to deny the request right at this moment. I want in writing what is basically the plan.
Okay.
That it would be reinstated. He's not going to have folks coming over to his mother's house. Because, young man, how old are you?
24.
Yeah, she does not have to give you a home.
Mm-hmm.
You got that?
Yes, sir.
So I want that laid out. That this is what the defendant is willing to do. I understand what Mom's going to do in terms of protecting her house, but I want what his commitment is in writing. So if he messes it up, it's his word. It's not something Mama didn't do. All right. And then I will consider I'll look at that and based upon what we talked about, try to get him released. I want also in there the CCOP portion of that in the order, and then I'll look at and do that. Okay?
Okay, so we'll look at the order after we get you the plan.
You get us a plan and then you just prepare an order for
Absolutely.
these, but I want everything laid out, spelled out as to what he's going to do.
Understood, Your Honor. I'll work on that today.
You're not an amoeba. I'll have him look it up when he gets out as to why I'm saying it. He knows why I'm saying that.
Thank you.
I was just in the room and that's how now go. Young man, you break that woman's heart. Go ahead.
Thank you, Judge. My understanding is that the last court date, the court told Mr. Washington that he was to come up with a plan as to what would happen should he be released. I believe Ms. Ikari-Akinruli had to file at that time, and she indicated that he was to go into the CCOP program. She reached out to Ms. Maya Dozier, and our understanding is he cannot be evaluated for that program while in custody. He has prepared a plan, is my understanding, as a letter for the court if the court wants to review it, is what I am told. And so his request is that the court would release him on a tether if necessary, so that he can go into the CCOP program, be evaluated by Ms. Dozier. And he does have family support here who would help him in any way, with his mother and his father are both in the courtroom. And so that's what his request at this time.
Oh, they're back. Okay. Okay. I just wanted to.
Yes, Judge. And so that's my understanding as of what occurred at the last court date, and what his request is.
You can get into CCOP program.
Yes, Judge. Since his bond's been revoked, he's been in here 3 weeks, and I think he has faced some harsh realities. That what happened.
The harsh realities of what?
What happens when you don't listen to Judge Simpson, when you don't follow your bond conditions.
Oh, that harsh reality?
Yes.
How's it been going?
Not so good.
So, how do you think you ended up here?
By not being truthful to myself, honestly, like I said the last time, and not being truthful to you, most of all.
And there's another person you weren't truthful with.
My mother.
Yeah. Out of all of that, that was the one that upset me. How old are you?
24. I'll be 25 on a Monday.
Oh, so we could keep you for your birthday?
In theory, you could, yes, Judge.
That's pretty cool. Do they do cake down there? No, they don't? No cake? Oh, bummer. You know something, young man, and it's kind of funny because when I sit up here, I kind of look out and I see people, and sometimes I see moms, and moms are here. You may not have done the right thing, but mama's going to be here to protect her baby, or as best she can. And when she got up and walked all the way across the courtroom to get away from that other, whatever her name was, she knew you were in trouble. Mom, you want him? You do? You're so lucky she didn't say no. Because if she had said no, you'd just be my guest. Is there anything from the people regarding this?
It's a copy of the letters going to go to the court. I'd like to see it before it's all signed.
I haven't seen. I haven't
didn't know if it was
seen.
going to go or not. That was.
Do you need to see it?
I don't need to see it.
As long as the court continues the testing, the people have no objection to this change in bond. If there are any positive tests, we will be asking the defendant upon your vote.
Again,
If there are additional positive tests, I should say, yes, there's 2 previous positive tests of great concern.
you know something, young man, you need to stay away from that stuff because either you're going to end up in jail or you're going to end up dead. That's just going to be the reality.
Sure.
So he's to enroll in the CCOP program. I'm going to put him on a GPS location tracking tether, and we'll reinstate his previous testing. You're on thin ice. You need to follow all of this to a letter.
Sure.
His previous bond will be reinstated with a GPS tether. We'll see him on the 6th.
Thank you very much, Judge.
Thank you.
Good talk.
Ladies and gentlemen, let's pull this all together. What we just watched is a compact, high-stakes example of how procedural safeguards, supervision programs, and human dynamics collide inside a courtroom. First, the facts that matter. The probation office reported 2 consecutive positive tests for cocaine. Dates referenced in court were 12/27 and 12/30. The defense promptly sent the samples for laboratory confirmation and asked the court to hold the administrative progress report in abeyance pending those confirmatory results. That request is standard practice. An initial positive on a point-of-care test often triggers confirmatory lab testing because false positives and chain of custody issues can occur. Asking to pause formal consequences until lab confirmation arrives is legally sensible. It protects the defendant from immediate penalties based on a presumptive test while also allowing the court to preserve due process. Second, the judge's focus here splits into 2 related concerns: 1, compliance with bond conditions and attendance, and 2, substance use and truthfulness. The judge made it clear that attendance wasn't the primary problem. Washington has shown he will appear, but the judge is alarmed by repeated positive tests and, importantly, by the prospect of dishonesty. Courts treat dishonesty very seriously because it undermines supervision and rehabilitation plans. Dishonesty here is not merely an emotional reaction, it directly affects risk assessment, community safety, and the judge's willingness to reinstate pretrial release. Third, the remedies and programs discussed are key. The court and counsel spoke about CCOP, the Community Corrections Program, GPS tethering, continued drug testing, and an individualized written plan from the defendant. These are complementary tools. CCOP, when properly assessed and implemented, provides structured supervision, services, and treatment options. GPS tethering is a monitoring tool that limits movement but critically cannot itself prevent exposure to substances in the home environment. The judge recognized that tether helps keep someone from leaving a location, but it doesn't stop visitors from bringing drugs into the house. That was the judge's practical point when she questioned whether tether had been effective previously. Now, the court's immediate action, bond revocation and remand, a serious step, followed by conditional language that allows reinstatement if the defendant produces a detailed, written plan and the court is satisfied with CCOP intake and supervision arrangements. That's a fairly common judicial posture: revoke to protect public safety and to get the defendant's attention, while still leaving a path for release tied to concrete mitigation, documented plan. Family involvement, treatment placement. Notably, the judge required the plan be in writing and include the defendant's own commitments, an enforcement-friendly move. If the defendant fails, the court has a paper trail that shows the commitments were his, not just his family's promises. A few practical points for viewers to consider. Lab confirmation matters. If the confirmatory results come back negative, the defense's position is strengthened and the court will likely reconsider the revocation stance. If positive, the court is likely to rely on the program commitments, monitoring, and stricter supervision, or custody until a treatment plan is secured. Family support is real and meaningful here. The mother's willingness to limit visitors and control the home environment can be a material factor in the judge's decision to reinstate release. But family support is not a substitute for formal treatment and documented compliance. Honesty matters repeatedly. The judge's anger about lying is operational, not just moral. It undermines trust and undermines the practical supervision relationship. So where does that leave Lante Washington? He's at a crossroads. The court has given a route back, written plan, CCOP intake, tether, and strict testing, but it's conditional and enforceable. For viewers, this is a case where small, concrete steps, written commitments, regular testing, treatment enrollment could restore freedom and progress. Repeated noncompliance will likely lead to continued custody. Now I want to hear from you. Do you think the court struck the right balance between accountability and rehabilitation? Was bond revocation the only appropriate immediate response? Or could stricter community-based supervision have worked sooner? Drop your thoughts below. The best comment will get pinned. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.